coming out, everyone. Obviously, during question time today, I spoke about the Prohibited Behaviour Orders Bill, and what I sought to do was speak about the ways in which this bill is aimed to be very targeted at the worst serial repeat offenders of antisocial behaviour in Western Australia. What I indicated in Parliament was that through the research that we've done in trying to design this legislation, we've looked at those people who over a 3-year period commit repeat offences. In terms of the adult boys, we found 20 people who had committed in excess of 20 offences each in a 3-year period. With respect to the children's court, we identified 20 young people who had committed in excess of 50 offences each over a 3-year period. What we've done is design very specific legislation to target those types of people. We expect about 70 to 80 applications for PBOs per year, but this is a central plank of the government's response on law and order to try and target that level of offending, which doesn't usually result in imprisonment, but in its cumulative effects really does destroy the lives of West Australian citizens.
So the legislation doesn't say that you can get a PBO if you commit 2 offences in 3 years?
What it says is, the court has to consider this. Have you been convicted of an offence, which is an antisocial behaviour offence? Have you then been convicted of another one within a 3-year period? Then is the court satisfied that it must prohibit you from doing certain things to prevent you from offending again? And the court must take into account the effect of your criminal record and offending on the community, as well as the interests of the person who has the order put on them. There's a great deal of discretion that resides in the courts, and what they're going to be required to do is to start off with, you're going to have to commit 2 offences in a 3-year period, but also the court's going to be satisfied, has to be satisfied, that if they don't put the prohibited behaviour order on you, you will offend again in the near future.
So it can be as few as 2 offences in 3 years?
It can be, but only if the court is absolutely assured that if they don't put the order on you, that you will commit another offence in the near future. So there's a great deal of discretion. It's actually a very high standard, higher than has existed in other jurisdictions.
You're trotting out examples of people who have committed 20 offences. That's completely misleading. You do it after 2 offences.
No, not at all. Because when you look at the legislation, the criminal record is going to be a very key component of your history. I'll go through it again. A person has to have committed and been convicted of an offence, committed and convicted of another offence in 3 years, and the court must consider that unless constrained from the lawful, otherwise lawful behaviour, the person will commit another offence. That requires the court to take into account the person's criminal record. I think it would be unusual, if not amazing, if someone who had no criminal record but had just committed 2 offences in 3 years would be caught by this legislation the way it's structured.
And as late as last year, you were saying that the age of children was known as 14. Even today, the Premier thinks that it's 14. It's actually 16.
It is 16, and we've modified it. It does make the legislation more moderate and more targeted. We just considered in all of the debates that we had in our cabinet that what we wanted to do was target this to the worst possible group of repeat offenders. And by going 16 and above, we're able to target that group. Keeping in mind though, and I think this is where the confusion on the part of the statement earlier arose, that the strikes, if you like, that you've accumulated before you were 16 can be taken into account.
But that's been reported though, hasn't it, that it's only 16, because when that came up, the national offence
no, there were a variety of views in Cabinet, and we looked very closely at this. And the debate surrounded about how do we target the worst possible repeat offenders.
Who actually decides if the name goes on the website?
That is a determination of the court, the judge. Now, there is a presumption that a person will have their details published if they are subject to a PBO, but the court retains the discretion to determine not to do that if they think that there are reasons why that should not be done. When the court orders that there be publication, the publication occurs and must occur by the Director of the Department of Attorney General on their website, but importantly it can be republished under the legislation. What we are expecting is that community newspapers, community groups, individual shopkeepers or whoever they might be have the ability to republish so that the community can be involved in protecting its safety and policing it.
So like wanted posters in the front windows of shops and shopping centres?
It will be open to individual community members within the groundwork of existing local government laws about posting bills to republish the details of a PBO in and about the vicinity, say for instance of their business. Let me give you this example. If someone is banned from going to a shopping centre, Galleria for instance, it would be open for shopping centre management to have a republication saying that this person is banned from this shopping centre.
So like a total wrap bag and photo underneath?
They'll have to republish precisely as it's published on the Department of the Attorney General website, so I think that you'll find that that'll be a fairly sort of modest format.
What about a photo? You know,
This is the Montenegro stops, isn't it? Why don't you just set them up down in Foxborough?
I think that truthfully is an unfair reflection of the legislation. What it does is it sets up a variety of stages, which means that it targets the worst possible offenders. Then what it does is it allows the community to involve itself in policing and protecting itself against people who repeatedly offend against the community. Now, we make no apologies, because what we've tried to do is target a real problem that exists out there, and I think that problem is clearly shown by the statistics we've used today.
So it's been 2 years drafting up legislation, pretty expensive process to pin 40 people.
Well, these are a very, very expensive group of offenders in terms of the damage they do to property, the misery they cause in the everyday lives of West Australian citizens. What we did was take 2 years to get the legislation absolutely right. What the public want is for the 70 or 80 incidences a year and people a year who really ruin the lives of the public to have an extra tool that the police and the courts and the community can use to stop this from occurring.
But theoretically then, if I wanted to set up a Facebook site dedicated to naming and shaming these people, according to your website, I could do that.
You want to do that, do you?
I
No.
may.
What I say is that you can republish. People will be able to republish inside a shopping centre, for instance. They can do that in the mechanism and by the means that they wish. But the republication is only of the details that the court allows, only in the circumstances that I've described. But that is a matter for the community.
And
So
when
it's a
the,
yes
when
then.
the PBO expires, you take it off your website and they're republished all over the world and you can't stop it.
Oh, well, indeed. I mean, it is an obvious fact that once something is published and republished, that it exists. But indeed, they have a life, they come off the official government website.
But people are labelled for life anyway.
Well, what we've done is we've said, in these circumstances, where you have continually and repeatedly committed offences against the community, we are willing to trade off on your individual rights as a criminal to try and protect the community. And what we've said is the balance we've tried to strike is to say that in limited and certain circumstances, publication is a means by which the community can protect itself. Now, that's the balance we've struck. The opposition seek to strike a different balance.
And just to clarify, how many people do you think you'll get?
I would expect, based on the information that the police have given to me, based on the drafting as they've interpreted it, about 70 to 80 per year. And look, I will be reviewing this legislation should it get through Parliament on a yearly basis to see how many we are getting. I can say that I think that we've been so careful and cautious here that my concern is not that we'll get too many. My concern is that we might get too few. But what I say is that we've done that to make it very, very targeted.
What if the R review shows the same as the UK review, which is that it doesn't actually work? That's what they scrapped it.
What review is that?
Well, they looked at the reoffending statistics and scrapped it after they said it didn't know what reoffending.
I actually don't think that's what happened in the UK, but I think the situation with the UK, and I'll make a couple of points about that. Firstly, this is a substantially different system to the UK's, based only on conviction, very narrow, very targeted. The United Kingdom, as you might be aware, has a $950 billion budget deficit at the moment, which is 70% of their gross domestic product. 40% cuts across every aspect of the civil service, including the ASMO system. To those people who say that it hasn't been a success, I would argue that one of the successful features of that system has been that in about half the cases where people have breached orders of the UK, they've gone to jail. The courts have treated it very seriously. So they are people who would have otherwise been offending against the community. But because of a system that we are going to put in place, the court will have the option to put them in jail.
Did they go to court before because of the breach or because they committed another offence?
Well, the breach can be another offence, or it might be something preparatory.
You just told us something. Did they go to court, go to jail because they breached the order or because they committed another offence?
They all breached. In some instances it may have been another offence, but what they were sentenced for, and the reason they went to jail, was the breach of the order.
Not the offence they recommitted.
Correct.
How much are you looking at the situation in Brisbane for?
Look, I think the British system is actually quite different. What we've done is we've picked the eyes out of the better parts of that system. We've developed it for our own purposes, our own geography. The the data that we've got from our court system as to who we're trying to target, I think what we've done is we've learned from the experience in the United Kingdom, and we'll have a very targeted and effective system here.
Of that 70 to 80 that you talk about per year, do you know how many might be Indigenous?
No, we've not gone into that level of detail, and I don't think that we could garner that from the records in any event.
When do you hope you get it through?
Well, we would hope that giving ourselves this sitting of Parliament, is the target. We want it through and up and running by the end of the year.
Have you looked anywhere else in Britain? Do these things
Well, these sorts of orders exist in various ways and forms in a variety of jurisdictions. We've had a look at some. Indeed, if you go through Hansard, you might see that Lana went in and tried to bring in that bill, and I think she was successful in actual fact, that brought in a form of these orders, but it only applied to public transport authorities, train stations, if you like. Now, the question I pose is if it's good enough to protect the users of public transport, why is it not a good enough system to protect West Australians at large? Too early to tell.
To what degree? We're constantly hearing about what people are trains.
Indeed, and this will apply also at large train stations. Well, I think that the point about that bill is it's simple, but the processes you had to go through were so convoluted and weak, that I wouldn't have expected it to move very well.
Just one more thing. On the guy that you read out today,
Yes.
aggravated assault, burglary, etc.
Going armed with tools for you.
I mean, isn't he in jail?
During that period that I read out, based on the record that we've seen, he only received 1 term of detention.
For how long?
I don't know.
And given that he was sanctioned by the courts so many times, what's putting him on a website and doing this?
Well, as I say, based on the United Kingdom experience, half the people who breached prohibited behaviour orders ended up in jail. And that is about the strike rate that we would envisage would occur here. So the point is twofold. First of all, police would be able to apprehend the person and charge them with breaching the PBO before they'd actually committed another offence. But in any event, the breach of the PBO is itself another offence for which someone can go to jail, and based on international experience, people do go to jail.